Right now, Section 26A, refund of import duty in certain cases. Refund of import duty in certain cases. So Section 26A. This is refund of import duty in certain cases. Now, when you say refund, the refund, it is 100%. How much amount of duty drawback is available? What is the maximum rate of duty drawback available? 98% under Section 74. How much refund is available? This is 100%, right? So this section is not comparable to duty drawback. Lots of people get confused that this is also duty drawback. No, this is not. Because in case of duty drawback, goods have to be returned or exported. In this, we have multiple options. Okay. So this is certain cases. Which are those cases? Very first thing required is goods are identifiable. Many goods have already been declared by the government as non-identifiable for the purpose of customs. So first requirement is goods are identifiable. Number two, the goods are A, not as per specifications ordered, or not suitable for the purpose. Or those are damaged. Any of the three things, either not as per the specifications, or not suitable for the purpose of import, or those are damaged pieces. Number three, if such goods are returned or exported or destroyed or transferred in favor of customs. Options are either returned to the same person, exported to another person, destroyed as per the rules, or transferred in favor of commissioner, right? That too within 30 days since removed. Extension may be allowed. The time period given in the section is 30 days, but extension can be granted by the office. So if such goods are returned or exported or destroyed or transferred in favor of customs within 30 days since removed, the amount of customs duty is refundable provided number one, duty drawback not claimed. So any one thing can be claimed, either a refund under section 26A or duty drawback under section 74. Both the things cannot be claimed. Number two, ITC not claimed. Or this is reversed. Number three, not used in India. Now, not used use of goods necessary to discover that the goods are not as per specifications or unsuitable or damaged is allowed. So quite possible many things are never known to be defective or unsuitable unless those are really put to use. Section says goods should not have been used in India. Further said use of the goods is necessary to discover that the goods are not as per the specifications or those are damaged or those are not suitable. That will not be considered as a use of the goods in India for the purpose of refund under section 26A. Now these are all terms and conditions prescribed under section 26A. So I've given you brief in the first, then we will go in the section. So complete note taken. Who said no? फटाफट कर लो अगर रह गया तो. जितना जल्दी सेक्शन खत्म करोगे उतना जल्दी फ्री करूंगा। देखो करिश्मा ने फटाफट कर लिया, उसको जल्दी जल्दी जाना है। Section 26A, where on importation of any of the goods, first thing is capable of being easily identified. Any duty has been paid on clearance of the good for home consumption, such duty shall be refunded to the person on whom this was paid. To whom refund shall be made? To whom refund shall be made? As a custom broker, you have paid the duty on behalf of the client. Refund should be made to you or to the client? This is refunded to the person by whom or on whose behalf it is paid. If the importer has paid directly, then he refund to him. And if the custom broker has paid on behalf of the client, then the client will get the refund, not the custom broker. Right? So this is a doctrine of unjust enrichment. So any refund will be given only to the person who has actually borne the burden of duty. Right? So the custom broker has paid on behalf of the client. So actually, who has borne the burden of the duty? The client. So refund will be given to the client, not to the custom broker. Now see, in what conditions? The goods are found to be defective or otherwise not in conformity with the specification agreed upon between the importer and the supplier of the goods. Two clauses covered in one. Goods are found defective or otherwise not in conformity. Actually, these are two different clauses. Right? So this or automatically helps you to bifurcate that into two different clauses. So goods are either defective or those are not as per the specifications, provided that the goods have not been worked, repaired, or used after importation, except such a indispensable to discover the defect non-conformity with the specification. This is the last line. Used to the extent it is necessary. Then the goods are identified to the satisfaction of ACDC as those are imported. The importer does not claim duty drawback, and the goods are exported. The importer or the relinquishes the title in favor of the abandons them to the customs, or such goods are destroyed in presence of the proper officer. So how many options are available? Goods are returned or exported, or those are transferred in favor of customs, so those are destroyed in presence of the officer as per the rules. But within how many days? Here it is. In such manner as we prescribed within a period not exceeding 30 days from the date on which proper officer makes an order for clearance under section 47. So within 30 days, all this should happen, provided that this extension is, this period can be extended. How much extension can be provided? That on sufficient cause being shown, the extension can be granted by the commissioner or the principal commissioner for a period not exceeding 3 months. So effectively, how many days are there? Maximum possible, how many days are there? फटाफट बोलो कितने दिन है? 1 + 3 120 days 90 days सब गड़बड़ है, सब गड़बड़ है. Yes, one person has written correctly 3 months and 30 days. 90 days, not there. 30 + 3 months, if you say 120 days, it is wrong. Right? So 30 days and 3 months. 3 months extension. Okay? Who will allow the extension? Who is having the right to allow the extension of time? Extension of time will be granted by principal commissioner or commissioner. Identification of the goods is done by the AC or DC. Who will exercise power under the section? Make a chart. Identification of the goods by AC, DC, extension of time by the PCC or CC. Okay, then now this is a prohibition. Nothing contained in the section shall apply to the goods regarding an offense appears to have been committed under any law. So transfer in favor of commissioner is coming here, right? And under section 23, already we have read the same condition. Any of the goods in relation to which any offense has been committed under any law, those cannot be transferred in favor of customs. Same thing applies here. An application for refund. This application for refund is required to be made. Just this refund will not be automatic within 6 months from the relevant date in the formal manner as may be prescribed. What is the relevant date? This relevant date given here is this. If there is an export, then order under section 51. If the title is relinquished, the date of relinquishment, and in case the goods are destroyed, the date on which the goods are really destroyed or rendered valueless. That is called the relevant date. So application for refund shall be made within 6 months. So without application, there is no refund, no automatic refund. No refund for the perishable items. If the goods themselves are not having a shelf life of more than 30 days, and during that period the goods are becoming valueless, no refund will be allowed. And board may notify the other conditions subject to which refund is available. So this is section 26A. Read carefully, and if you have any question, we can talk about this. Yes, Prabhat.
Sir, if we paid that is a double and then the excess duty, for example, the importer is by mistake he paid that is a double time that is a duty amount in online. Okay, when we are going to be applying for that is refund of that duty, sir. That also it will come into this section.
Refund whatever amount of the duty has been paid, right? If the goods are being returned or exported or etc., then whatever duty has been paid fully refunded.
No, my question is like this, sir. We filed the bill of entry, assessment has been completed. What happened actually, the importer by mistakenly 2 times. First time he's paid that duty, that is not at all reflected in that ICBLR. So due to that is urgency, what he did is actually he has been, second time also he's paid the duty. Okay. Then first time whatever he's paid, it is not at all reflected in the ICK. For that he's applied for that a refund of that is a duty amount. Whether that it will come into this section or no. Okay.
For that, actually, no section of the act is applicable.
Okay.
So the amount paid in excess, that is not a duty.
Okay.
Even when you make an application under section 27, that is also in relation to the amount of the duty. Now, the second time paid, there is not the duty at all. That is the amount paid by mistake. For that, no time limit is applicable for making an application.
Okay.
Okay. Yes, Kangyan. Kangyan. Refund of double duty takes 2-3 years for processing. Yes, this problem is there. It is not instant, right? But slowly, within next 6 months, you will find a big change. Within 6 months, lots of changes are going to come. Yes, Justin.
ये एक केस मैंने हैंडल किया था DRDO के लिए, उसमें डबल ड्यूटी पेमेंट था, जहाँ पे इंपोर्ट आया था मुंबई ओल्ड पोर्ट में, और पहले बिल ऑफ एंट्री फाइल हुआ नावाशेवा के अंदर बिल ऑफ एंट्री फाइल हुआ, DRDO ने उसका ड्यूटी पेमेंट किया, ड्यूटी पेमेंट करने के बाद बिल ऑफ एंट्री फाइल किया था, उसके ऊपर ड्यूटी पेमेंट किया, फिर पता चला कि वेसल बर्थ हुआ है ओल्ड पोर्ट में, फिर ओल्ड पोर्ट में नया बिल ऑफ एंट्री फाइल करके उसका फिर दोबारा ड्यूटी भरा गया, और वो भरा था 2017 में, और उसका रिफंड एप्लीकेशन मैंने पुट अप किया था, मैंने फॉलो अप करके प्रोसेस किया, और रिफंड सैंक्शन हुआ 2021 में.
Too long a period.
उस पे उनको आइसगेट हेड ऑफिस से उनको कंफर्मेशन था कि भाई उनको पेमेंट मिला। आइसगेट हेड ऑफिस में एप्लीकेशन दिया, वहां से उनको कंफर्मेशन मिला, हाँ भाई पेमेंट आया है, ये कस्टमर से इस ये आईसी के अंदर पेमेंट आया है। ये सब कंफर्मेशन लेने के बाद वो प्रोसेस करते हैं।
That is their process. So Gaurav was asking how the ITC can be reversed. Reversal of ITC can be done by adding the amount of the reversal in your next month liability. That is not under customs, that is under GST. Yes, Siddhi.